I'm going to call this meeting to order. Welcome to meeting number 133 of the House of Commons Standing Committee on Indigenous and Northern Affairs. As always, we begin by acknowledging that we are gathered on the ancestral and unceded territories of the Algonquin and Anishinaabe peoples, and I want to express gratitude that we're able to do the important work of this committee on lands that they've stewarded since time immemorial. I also want to do a special welcome today. We have a delegation of students from Nunavut Sivunnik Samut visiting. Welcome. And we also have a number of members joining the committee today, are Mr. Sandley and Mr. Vidal. Thanks for filling in today. In the spirit of being efficient, there's a couple of things I want to mention pursuant to the motion that we passed last Thursday. I am going to need to pause briefly at routine proceedings so I can table that report in the House virtually. So I will pause briefly when we get to that. And I also want to mention that thank you to the member who noticed that tomorrow's meeting was due to be in audio only. That's since been rectified, and tomorrow the meeting, which will be a very long one, will be televised from 10 a.m. to 10 p.m. or whenever we will finish. So with that, pursuant to the order of reference of Wednesday, June 5th, 2024, the committee resumed consideration of Bill C-61, an act respecting water, source water, drinking water, wastewater, and related infrastructure on First Nations lands. So to help us with clause-by-clause consideration of Bill C-61, I would now like to re-welcome our witnesses here today. We have Nelson Barbosa, the Director General, Community Infrastructure Branch from the Department of Indigenous Services. We have Rebecca Blake, the Acting Director, Legislation, Engagement and Regulations. And we have Douglas Fairburn, Senior Counsel from the Department of Justice. And I do want to remind members again that the amendments are confidential and sub-amendments are to be shared electronically or in paper in both official languages and sent to the clerk for distribution. So with that, we can resume clause-by-clause consideration. We were at CPC 6, which is in clause 22. And just so you know, I will have to rudely interrupt at some point to pause. But until we get to that point, I will open it up to the Conservative Party to discuss CPC 6, should they be willing to move that. And Mr. Vidal, I'll turn the floor over to you.
Thank you, Chair. I guess my understanding is because I'm subbing for Mr. Melillo today that it's my responsibility and privilege to move his potential amendment. So on behalf of Mr. Melillo, I would like to move CPC 6, that Bill C-61 in Clause 22 be amended by replacing line 24 on page 13 with the following. Subsection 1, and any such regulations be co-developed with that body. And Chair, you're right, I am a visitor today, but I have some history on this committee, as most people are aware. And just a couple comments maybe in support of this amendment on behalf of Mr. Melillo. Basically, this amendment is ensuring, or would ensure, that these regulations and whatnot are truly co-developed. There has been a number of other amendments earlier in the process on a number of other sections of the bill with similar amendments made, and I think have been supported for the most part. And so we're going to ask that the members of the committee would support this amendment to ensure that we really do get legislation and regulations that is truly co-developed. It seems interesting to me I don't know whether I call myself a newcomer or an old comer to come back to committee, but it's interesting to me that in just kind of preparing for this, you know, there's been a lot of kind of language around co-development and how this bill was co-developed with nations across the country, with organizations representing nations across the country, but yet when I look at this, there's like 130 plus amendments being proposed. A number of them have actually come from individual nations, from regional organizations representing nations, and even from the AFN. And I guess my challenge to that would be, in the drafting of this legislation, if it was truly co-developed, why do we have 100 plus amendments being brought forward, and a number of them by individual nations and by organizations representing, whether it be regional organizations or the national organization, the AFN? So I think it stands to reason to support the idea that adding the language to make this truly co-developed, to make sure that the individual nations that are impacted by this legislation have a say in the process, in the regulations that impact them. I think that's the purpose of this amendment as I see it, and I will leave it at that, but I just ask for member support in making this legislation truly co-developed.
Thank you very much, Mr. Vidal, and it's great to be on this committee with you. Again, I know we were both members of this committee a couple years ago, and so welcome back. But with that, I'll open it up to debate on this motion, and I see Mr. Batiste has his hand up first.
Yeah, and I think when reading the actual portion of this and talking about the minister's enforcement, it says, if requested to do so by a First Nations governing body, the minister may. And when we're looking at adding an additional layer of bureaucracy and saying that it must be co-developed, it kind of, to me, seems like this only goes forward if the First Nations governing body actually asks the minister to do so in regulations. So it requires the consent and approval and actual action by the First Nations in order to action this portion of the legislation.
I'm afraid I'm going to have to suspend very briefly here. Back to order here.
You just wanted to take this thing up.
Just wanted to get in the middle of that clip, Mr. Batiste here. So apologies for that. I'm going to actually have to suspend in about 5 minutes here. So something unusual was presented here. And so, Mr. Batiste, I'll turn it back over to you.
So to the youth in the room, you see, even when you grow up and become elected, they'll still cut you off when they want you at the front of the class. So I will just... I think where I was going with that is it seems that the only way that this article gets actioned is if the First Nations governing body is requesting it. To me, that actually is a higher threshold besides the idea of co-developing because it requires a First Nations governing body to take some action to request the minister to do that. Is that a somewhat accurate reading of how this particular article of the legislation comes about? And do we need the extra layer of bureaucracy to co-develop something that's actually being asked for by the First Nation itself?
Thanks for the question. It's good to be back. Yeah, I think that would be an accurate interpretation. In order to be expeditious, we've kind of covered many of these concepts before, so I'll just go over them briefly. I think we had talked about in the past about a lack of a better alignment between words of consultation and cooperation found in UN DRIP in previous meetings, a bit of an ambiguity on what the litmus test for understanding what co-development means, particularly in a legislative context. So those have been two kind of periods of caution that we've had conversations over the last couple of weeks on. I think also, just in terms of this amendment, it talks about must be co-developed with that body, which, just reading the text, says First Nation governing body of a First Nation, which I assume means the First Nation, but also then says and governments of provinces and territories. So there's, I think, a lack of. I'm anticipating, or maybe a thought in my mind is that this sounds like co-developing with that body, meaning the First Nation, but it does say and. So there could be interpretation of co-development with provinces and territories, which we talked at length on at the closeout our last meeting. So I would concur about the cascade of consistency of terms, consultation cooperation, adherence to UN DRIP, previous conversations we've had with provinces and territories, and in my mind, just reading this text as an official, some ambiguity on what that body means in reference to a full phrase. Thanks.
Just in following up, if I'm a First Nations community who's asked the minister to take on something around protection zones in this enforcement criteria, there are some communities out there that don't have the capacity to work on co-development. Could this end up delaying for some communities that don't have the capacity to work with federal officials on co-developing something instead of just asking the minister to do something in a BCR? I'm wondering, could this extra portion about co-development add delays to communities without the capacity to negotiate or co-develop something around protection zones?
Yeah, thanks for the question. I think it could. Ambiguity aside, I think, again, that is a significant bar, and a potential significant hurdle with lack of kind of clear definitions. So it certainly could contribute to lack of implementation or delays.
Okay, for those reasons, I think our government must vote no to that.
Thank you very much, Mr. Batiste. Next, I have Mr. Vidal, then Mr. Shields, then Ms. Idlout, and just so you're aware, I'm going to interrupt probably in the next 2 minutes or so. But Mr. Vidal.
Thank you, Chair. I'll try to be quick and be done so you have a nice break in your 2-minute gap here. I guess I would respond with this particular clause in the legislation is entitled consultation. And the language of the clause says the minister must consult and cooperate with the First Nation governing body or of that First Nation and with the government or province or territory in which the protection zone is located before making, and our amendment adds on to that such regulations must be co-developed with that body. I guess I would probably, and without being too blunt, I would probably, in my experience, the minister in this government's response to consultation and cooperation has not been what I would say is stellar. And I would say, rather than use my opinion of that, let me read you a couple of quotes. One here from the chief of Onion Lake Cree Nation, which is literally a couple hundred kilometers from where I live, and he says,
Mr. Vidal, I'm going to have
"You're
to
going to do it?
briefly
Okay,
suspend
sorry,
here.
I wasn't fast enough."
Business here, and apologies for that, Mr. Vidal. As you can see, definitely business related to the work of this committee, but I'll turn the floor back over to you where you left off.
You realize how old I am? I probably forgot, right? So, just kidding. I was about to quote a couple of people that just speak towards this need for true co-development and maybe a lack of actual consultation and cooperation. We're just trying to ensure that happens. So, Chief Henry Lewis from Onion Lake Cree Nation, he was at committee on the 3rd of October just recently, and he said Onion Lake Cree Nation has protocols outlining consultation on what requirements governments and industry must follow when engaging us through our own process. This has not been followed, he said. And I'm not going to read all these other quotes, but Grand Chief Alvin Fiddler, we acknowledge that some First Nations have had opportunities for input in the drafting of this legislation, but we do not agree that this legislation has been co-drafted. Chief Bill Joe Tucaro from Mikisew Cree Nation in September said there's been absolutely no consultation in regard to this bill that's being rammed down our throat. So my point being in the quotes is this is not my opinion as to the lack of consultation and cooperation. The reason that we're trying to add some language and substance to this part of the legislation to ensure that the parties affected by the legislation are in fact included in the creation of regulations in the legislation would be kind of my pushback on why this amendment, I believe, is extremely important. Thank you.
Thank you very much, Mr. Vidal. Next, I have Mr. Shields, then Ms. Idlout, then Ms. Atwin.
Thank you, Mr. Chair. I appreciate the comments you're making about concern over adding layers. I mean, the legislation could have been simplified and we could have been working at drinking water much quicker, but it's much more complicated. So when we get more complicated, the comment that maybe some nations don't have the ability to work through the process of the regulations of working through it. But in my mind, if you don't make that attempt, at the regulations, because I've been around a long time. I've seen legislation provincially and federally a lot. But we all know where it comes down to is the regulations. The regulations are the pieces in it. I think the regulations are a critical piece. And at least you need to be able to say to each nation, give them the opportunity to say yay or nay to wanting into that, or if there's a way that they can do it through different associations to say, this is a template that others have used. Would you like to be in on this conversation? You may not have developed them yourself. And that happens a lot in sharing when people work on regulations. I've seen it a lot of times where smaller communities just don't have those resources, but they depend on their association, or they work with their neighbors to develop that skill set to work with response to regulations. So in my mind, if the legislation is built with the layers that are in it, we don't want people at the end of it, a nation, to say, I didn't get a chance to have my say. I didn't get a chance to react to those regulations. This is a once-in-a-lifetime piece of legislation. And so that, to me, says it's important that everyone has their say, and I think there's ways to support all nations in different mechanisms so they feel like they've had their input. I understand your thoughts on creating another layer and all the bureaucracy and may go with it. But I think we have a lot of nations in this country who really are looking at this as something that's going to make a change in their nations, and the regulations are how it's implemented. Thank you, Mr. Chair.
Thank you very much, Mr. Shields. Next, we'll go to Ms. Idlow.
Thank you. I am particularly missing the interpreter that I normally have, because it would have been lovely to speak Inuktitut with the Nunavut Sivunik Savut students here, who I welcome as well. It's so good to see them here. Regarding CPC6, I do support it and wanted to echo as well what our colleague Gary was saying about the lack of true co-development that we've heard from First Nations. I do recall as well when we had department officials appearing before us as witnesses, I asked them how many of the First Nations in Canada would be impacted by this legislation. And their answer was about 570 to 580 First Nations would be impacted by this bill. And I then asked them, of those up to 580 or so, how many were engaged in this so-called co-developed process. And their answer was only 100 and something. when my staff at the time did the math, that resulted in only 30% of the First Nations who will be impacted by this bill having been engaged in this so-called co-developed bill. So I absolutely agree with the Conservatives with this amendment, that including co-development at this stage where First Nations are afforded the opportunity to truly be engaged in decision-making surrounding water, surrounding their jurisdiction, and whatever the regulations might be, given that up to this point, they haven't been engaged enough. Even if we hear that this has been co-developed, the feedback that we heard from First Nations was that there were too many that were left out of the process. Indeed, earlier this afternoon, I met a chief of a First Nations who hadn't even heard of C61. So I think that if there's a First Nations that is in Canada that has not even heard of C61, there is a major failure of not including First Nations to this point, and as such, I'll be supporting this amendment. Kuyanimi.
Thank you very much, Ms. Idlout. Next, we'll be moving to Ms. Atwin.
Sorry. Thank you very much, Mr. Chair. And we've gone down this road many times. And first I'd like to know where specifically that amendment came from, to be honest. I understand what we're trying to achieve. I think we all want to achieve that. I'm just wondering if the specific amendment proposed, where it's specifically found in the bill, is it going to achieve the outcome that you think it's going to achieve? And we're hearing from our legal team, we're hearing from those who are experts in this, that it could actually slow down what we're trying to achieve. And so that's my concern. And I'd also like to just highlight, I wish it was truly a co-developed bill. We know that it was as close to co-developed as we've ever seen with the legislation in Canada, so that needs to be clarified as well. I'd love to get there, and we need to get there. And so I'd love, again, just to see what's the best case scenario and what's the worst case scenario in terms of how this amendment would impact the overall bill.
Yeah, thanks for the question. I think, best case scenario, I think, is the objectives that you're all speaking to, which is a regulatory standards and policy regime that is led and shepherded by First Nations, with Canada as a partner at the table, where there's an acknowledgement and affirmation of rights and lawmaking in that space, and First Nation laws are put at the forefront on protecting their waters, and there's a provincial space and territorial space where they can protect waters together. I think the opposite side of that coin is what some others are highlighting, which is ambiguity of the term, a high and unclear definition of what co-development means, a stagnation in progress, a lack of alignment between provinces and territories, and pushing people away from cooperation and moving them into a more adversarial or legal context. So that this is I guess the thread of the legislation and the needle that it tries to weave. Thanks for the question.
And just kind of unpacking that further, again, we've addressed this similar thing of similar amendments, is that I do wish the co-development piece was there for First Nation governing bodies, but entering into the conversation with the provinces and territories, again, is further complicating. And so that would be a concern, as you mentioned, that it's not clear. The other piece, again, is just we're under 22, clause 22. So it's all about if requested to do so by a First Nation governing body, yada, yada, yada. So it's already implied that they're going to be the ones requesting that. They're the ones at the table who are stewarding this process. And so I do see it as an additional layer. And again, we did work with many, many partners to put this together. And so I'm wondering specifically where that amendment came from our Conservative colleagues. I just would be curious. I think it's important to the conversation. But those are just my thoughts for now. Thank you.
Thank you very much, Ms. Atwin. Next, we'll go to Mr. Shields.
I think you made my case when you said it's implied. If it's implied, I want to make sure it's there. Not implied. Yep. Don't want any ambiguity. Just no ambiguity, not just applied, it's actually very clear. And that's what we've been asked from First Nations, make it clear. No ambiguity. They've stated that.
Thank you very much. Mr. Shields? Not seeing any other... je vais aller à ce moment à Monsieur Lemire. Vous avez la parole.
Mr. DeMayo, thank you. We're going to go by the principle of collaboration. That's it. That's all I had to say.
Lemire. Alors, à ce moment, on peut aller à une vote.
So we can proceed to the vote.
On division at this point. Okay. So CPC 6 is carried on division, which will take us to CPC 7. And I'll open the floor up. Mr. Vidal, the floor is yours.
Thank you, Chair. On behalf of Mr. Malello again, I have the privilege of moving Amendment CPC 7. And the language of that amendment is that Bill C-61 in Clause 22 be amended by adding after line 24 on page 13 the following. Subsection 3, a regulation made under subsection 1 must not come into force unless the First Nation governing body of the First Nation consents to it. My comments on this are probably pretty simple, Chair. I understand there's been a fair amount of conversation around consent at this table over the last few meetings, and I think we've heard the arguments many, many times, and I think this is just another step on that journey of ensuring that the nations actually consent to the regulations being made that impact their nations or the water that impacts their nations. So I think I'll just leave it at that. I believe this just adds some assurance that consent happens. So thank you, Chair.
Thank you so much, Mr. Vidal. So CPC 7 has been moved. Is there I'll open it up to debate. Is there anybody that would like to intervene at this time? Ms. Atwin.
Just again, that we've had this conversation multiple times around the same pieces, and so not to reiterate, and in the interest of time, I think that we're going to probably land at the same place. So,
Thank you very much, Ms. Atwin. Not seeing any further hand. Ms. Idlot, sorry, did you have your hand?
Yes.
I'll turn the floor over to you.
I'm wondering what the effect of adding a sub-amendment would have if we added after governing body provides free, prior, and informed consent. And if the Conservatives would be amenable to that sub-amendment.
Thank you very much, Ms. Idlout. I know that this hasn't been officially moved as a sub-amendment, but I'll just remind all members that any sub-amendments do need to be submitted in writing as well. But I think before that, I'd be happy to open it up if there are any other comments on Ms. Idlout's suggestion. Mr. Vidal.
I would just comment on our side, we'd be happy to look at it in writing and potentially support it.
Thank you very much, Mr. Vidal. In that case, I will just mention to Ms. Idlout, should you wish to move that sub-amendment, please say so, and then if you could prepare something in writing to circulate to the committee, and maybe we'll briefly suspend for that sub-amendment to be circulated.
I'll send an email right now.
Great. Thank you so much. And with that, we are going to briefly suspend.
Thanks for the warning.
Colleagues, calling this meeting back to order. So we left off on the sub-amendment. The NDP is moving to CPC 7. That amendment has been submitted in writing and translated and has been circulated, so all members should have that at their disposal at this point. But I'll turn the floor over back over to Ms. Idlout should she wish to speak any more on this topic.
Just to make sure that it's clearly reflected in the blues, the sub-amendment that I've provided to CPC 7 is to remove the words "of the" after governing body and replace it with provides free, prior, and informed consent to it. I think it's pretty clear what the intent of this sub-amendment is, for the time to get it admissible.
Thank you very much, Ms. Idlout. So we're going to move to debate on the sub-amendment. First, I see Mr. Batiste. I'll turn the floor over to you.
So I'm wondering how something comes into free, prior, informed consent. How do we demonstrate that? If I'm a First Nations community or Atlantic First Nations Water Authority, can you tell me the steps that a First Nations community would now have to go through to ensure that this, in practicality, works? How do they do that?
Thanks, Mr. Batiste. Ms. Idlow.
It's already in the Constitution. They have to.
when we're debating bills such as these, I think it's important to remember the intent of our debate and the intent of this bill. As we discussed in this bill, we've been trying to ensure, as introduced, that Bill C-61 hands over jurisdiction over decision-making regarding water. So having had Bill C-15 become law, UNDRIP become law in Canada, this would help strengthen the ability of First Nations to ensure that they are exercising their inherent rights, as well as what we've passed in Parliament under Bill C-15 for UNDRIP. So free, prior, and informed consent. The way that I could see it implemented is that there would be consultation. There is a right to participate, especially because it includes the right to their lands, territories, and resources. So ensuring this declaration for free, prior, and informed consent would make sure that First Nations are engaged fully, as has been discussed at this time. To this time, we've heard, for example, that only 31% of First Nations were consulted in this so-called co-developed bill. I mentioned earlier that I met a chief of a First Nations this afternoon who has never even heard of C-61. So these concepts of ensuring consent, concepts of ensuring free, prior, and informed consent will help to make sure that First Nations can be engaged the way that they need to be, especially with Canada's colonial and genocidal policies continuing to impact the work that First Nations try to do. This would be a real recognition, a real form of reconciliation, ensuring that First Nations can give the free, prior, and informed consent even at regulation stage.
Thank you very much, Ms. Idlout. I'm going to hand the floor over now to Mr. Batiste.
Yes, and we agree with the overall principle of free, prior, informed consent. I agree that all of UNDRIP legislation and the principles within that should apply in the guiding principles. But I'm asking you, how does a community, there's 630 bands, more than 630 bands in Canada, how are we asking each of those to demonstrate free, prior, and informed consent? What is the mechanism? What is the thing that they do to show? It's not a thing about whether we agree with the general principle. I agree with the general principle. I'm asking you, how does a First Nations community show the free, prior, and informed consent to satisfy this in the legislation? Because if we don't have an answer to that, then we're going to add a layer of bureaucracy to this that makes it impossible for it to be implemented. And so I need a very specific instrument that a First Nations can do to show free, prior, informed consent. Because we're in agreement with it, but I need it to be clear what a First Nations community has to do in order to have this implemented in their community. Is it a ratification? Is it a Bands Council resolution? Is it a referendum? Is it an agreement? Is it a memorandum of understanding? I need to know the exact instrument. Otherwise, what we're doing to a First Nations community is giving them no way to implement this.
Thank you very much, Mr. Batiste. I see that Mr. Vidal has his hand up, but Ms. Idlout, if you'd like to weigh in on this point before that, I'd like to give you the opportunity.
I do want to weigh in. I know that the governing party has been clear that C-61 is something that they don't want to see actual engagement of First Nations. When they introduced this bill, they were touting it as the first fully co-developed legislation. We were quite excited to hear about it. Throughout the whole study of this, we had such a huge number of interest in this bill. We had so many First Nations telling us that the consultations were not sufficient, that indeed when I asked the federal bureaucrats to explain to us how much engagement there was, that's when we learned that it was only 31% of the First Nations that would be impacted that were engaged in this. When we're talking about adding free, prior, and informed consent into this, the sub-amendment, we're talking about making this bill, C-61, compliant with UNDRIP. Right now, as I've said before, C-61 falls below UNDRIP standards. It's unacceptable that this Liberal government continues to introduce legislation, as it did in previous bills, to continue to introduce bills that fall below UNDRIP standards. How that happens is up to the First Nations. How that happens should be the First Nations decide. As this Liberal government keeps saying, you don't want to be too prescriptive. When we've suggested amendments, you've said, oh, it's going to be too prescriptive. Now that we've submitted another sub-amendment, now you're asking me to give you a prescriptive answer. I don't think that we should tell First Nations how they are going to share their free, prior, and informed consent. I know that, for example, that we've heard in the past that there's going to be an UNDRIP action plan. I know that there are other instruments like the United Nations Office of the High Commissioner for Human Rights that has provided documents. There are documents and instruments out there that will answer that question, and it's not up to us to answer or prescribe that response.
Thank you very much, Ms. Idlout. Next, we're going to go to Mr. Vidal.
Thank you, Chair. Just a quick question, maybe, and a quick comment. I guess my question back to Mr. Batiste would be, and maybe to the officials, would be obviously the concept of free, prior, and informed consent is very much an integral part of C-15 or UNDRIP legislation. One of the witnesses here at this committee in September, Dr. Littlechild, referenced UNDRIP in his testimony, and I guess my question maybe to Mr. Fairbairn, I'm sorry, I'm trying to make sure I say it right without embarrassing myself. In response to Mr. Batiste's question, what in the context of the UNDRIP legislation, how do we acknowledge free, prior, informed consent there? There's got to be a definition there. It's legislation that's been passed. It's legislation that we've adopted. How do we determine free, prior, informed consent as it relates to UNDRIP from a First Nation then? Right. And I think that's if the challenge is how do we prescriptively define that, well, how do we do it for UNDRIP, for that legislation?
Right. There's no actual definition in the UNDA, the United Nations Declaration on the Rights of Indigenous Peoples Act, on FPIC. Canada has an obligation to ensure that its laws are in conformity with the UNDA, with the United Nations Declaration on the Rights of Indigenous Peoples. And there's also an obligation to develop an action plan, which was developed by the Minister of Justice. But it leaves that issue of FPIC to be decided at a future date.
Thank you very much, Mr. Vidal. I see Mr. Batiste has his hand up. We'll go there next.
Yes, I know, Gary, you're coming in and subbing in, but in previous discussions we had about how we show consent or how we show free, prior, informed consent, when it was specific to a First Nations band, we used the term BCR to demonstrate that. That's fine. There are also others who will do things outside of a BCR with other ways of doing it. I feel that when we're talking about legislation, it's great to have these principles up in the air, but as someone who lives in a First Nations community, who knows what mechanisms are available under the Indian Act and what's currently there, I need to find languages that all 630 of those First Nations bands would be able to understand, and to not have varying degrees. that they have to prove individually as bands throughout this process. So I was talking to my colleague Martin Shields, and when he saw consent, he said agreements. At least as someone who went to law school, who knows what contractual law is, I know what an agreement is. And I know what a BCR is. What I do not know is a large-scale free prior informed consent mandate that we're putting in this legislation that might end up making the implementation of this legislation impossible. And I'll ask the officials, is having these kind of terms that aren't really introduced within communities, is it going to delay or is it going to jeopardize the actual implementation of First Nation clean water regulations on reserve?
Yeah, thanks for the question. I think my response would be similar to those of co-development. I think I agree about the FPIC being entrenched in law in other places. The lack of definition, the lack of clarity could seriously impact how the bill is actualized, how it is implemented. It does set, again, a high, I'm not going to repeat myself, but just quickly, it sets a very hard bar that is unclear, in my mind, on how that will be achieved. And so in the past, we have put, I would say, a quantifier or a qualifier around what consent meant through BCR, or it could be other actions. That would be a bit ambiguous in this context, and I would feel that the ambiguity, this section is about implementing something. And I wonder to myself, how would this be implemented?
Thank you very much, Mr. Batiste. Next, we're going to go to Ms. Atwin.
Thanks. It's really clear to me that I think what we require is legislation around FPIC, that it needs, I mean, that would be very helpful in this circumstance. And then we could, of course, refer to it. We have the definition. So we're missing that component, which is very clear, which we can address, I hope, at some point. But right now, we're working on an act respecting water, source water, drinking water, wastewater, and related infrastructure on First Nation lands, which also is very specific as well. And I just, we also enshrine the human right to water, which I think is really important. And I think that also lends itself to this conversation. And what does that look like in actuality as well? And I think that we have yet to really see that. And I think that's a really nice piece that's been added to the bill. So I wish we had that guiding principle. I wish we had that other piece of legislation that has that definition, but we don't. And so that's my fear. That the task at hand is what we're looking at now. And I do want to go back to just around the consultations for the bill. And I know you've gone over this many times, but I know it's a preoccupation for a lot of us. We have heard from individual voices across the country. We have heard from specific communities as well. And so can you just, top level, again, what did that look like? Because I also think it demonstrates some of the difficulties in what that definition would be. If we're posting something online and everyone can just look at it, is that consultation? Are we holding, seminars or gatherings in community and that's, sanctioned? Are all members of that community? Say you've got 725 registered members, maybe some live in Hawaii, maybe some are. So I'm just wondering about the mechanics again. And without that separate piece of legislation that sets all that out, what we're doing right now puts this bill, the one we are tasked to get through in this committee, it puts it at risk. So if you could talk a bit about the consultation piece again for me, but thanks.
Yeah, I'd be happy to. The department did submit a brief to the committee on the development process of this bill. But in short, I've had the pleasure of being in this committee several times and speaking about these actions, and I'm happy to briefly summarize them again. In short, the consultation process on this bill was unprecedented in the history of Indigenous Services Canada. It really began in 2018 with engagements with First Nations that AFN led and we supported, and those were accelerated in 2020 with the posting of 2 consultation drafts online for all Canadians to review, a first time that's ever been done in the history of this department. We sent at least by my memory 3 correspondents from the minister to every First Nation to access and review the legislation. We opened up daily town halls in order for people to kind of support engagement. we engage directly with rights holders based on their assembly and based on their wishes coming to their lands from coast to coast. And because some previous comments were attributed to comments that I made at this committee previously, I did state that there are 634 First Nations, about 580 of them are bands, and First Nations who chose to engage in that process was approximately 130. It does not mean that the ISK consultation reach out was limited to that, but the window of opportunity was there, and we tried to socialize that as best as we could, and maybe we learned some lessons in that process and how we can do better. But I can absolutely say that the efforts that we undertook were new. We can continue to do better, but it was a lengthy process, and I would say, because the National Chief was here as well, that AFN led a parallel engagement process, which was concurrent and in addition to the aforementioned process that Indigenous Service Canada led with the minister. So certainly comprehensive, and certainly a variety of views on and interpretations of what that meant: consultation, co-development, and consent. Thank you.
Thank you very much, Ms. Adwin. And we're moving next to Mr. Vidal and then Ms. Kazan after that.
Thank you, Chair. And as Mr. Batiste aptly pointed out, it's been a while since I've been at the table with all of you, and there just seems to be a little bit of an irony here for me that I was here at this table when we had the debate around UNDRIP, and it's almost like we're making opposite sides of the argument here. Our concern back then was looking for a clear definition of FPIC, and now the argument from the parliamentary secretaries is that we don't have that definition when it's included in the legislation. So maybe we need a definition of FPIC. Well, however that was 2 years ago, I think that was the argument we were making, is we were totally supportive of the legislation if we just understood what FPIC meant, right? And so it seems kind of ironic now that when we try to include that in a specific piece of legislation, that's a hindrance to the progress. So maybe to the officials, what would you see as a way forward to getting a definition of FPIC that would apply to UNDRIP and apply then when this is now inserted in other legislation? Maybe that's the impetus that needs here to solve this impasse, because here, I mean, it's kind of ironic that my Liberal friends are arguing exactly what I was arguing a couple of years ago in the context of we need clarity to this definition. And without that, we struggled because of the impact it might have on decisions down the road. Well, here we are. Here we are. That's right. That's all I got. Thanks. What's that?
Solution.
Thank you very much, Mr. Vidal. Next, we'll go to Ms. Kazan.
So I know that we're all talking about a definition of FPIC, and I actually have one from Justice. So I'm going to read it. It comes directly from the federal government Justice Department. It says the following: references to free, prior, and informed consent are found throughout the Declaration. They emphasize the importance of recognizing and upholding the rights of Indigenous people and ensuring that there is effective and meaningful participation of Indigenous peoples in decisions that affect them, their communities, and territories. And I want to say that this is coming directly from the Justice Department. More specifically, FPIC describes the processes that are free from manipulation or coercion, informed by adequate and timely information, and to occur sufficiently prior to a decision so that Indigenous rights and interests can be incorporated or addressed effectively as part of the decision-making process, all as part of meaningful aiming to secure the consent of affected Indigenous peoples. So we actually have a definition currently. I'm reading right off the Justice page. FPIC is about working together in partnership and respect. In many ways, it reflects the ideals behind the relationship with Indigenous peoples by striving to achieve consensus as parties work together in good faith on decisions that impact Indigenous rights and interests. Despite what some have suggested, it is not about having a veto over government decision making. FPIC is not a veto. Like, it's all laid out by the Justice Department. It has a very clear definition of FPIC, and I just want to add that we passed Bill C-15 in the last Parliament. Bill 15, Article 5, stipulates that all legislation going forward has to be compatible and consistent with the United Nations Declaration on the Rights of Indigenous Peoples. The reason this legislation is taking so long is because your government, the Liberal government, has failed to do that. So now we are in a situation where only 30% of First Nations have been consulted, meaning you have not met your FPIC standards as outlined by your Justice Departments that the federal government must adhere to. So now we're here. So we have the definition. So I'm not sure what the issue is in terms of incorporating FPIC when the Justice Department has defined it. The other thing I'd like to point to is the UN expert instrument that clearly outlines UNDRIP. We are obliged to uphold international law, and I can read it. Free, prior, and informed consent is a manifestation of Indigenous peoples' right to self-determination, their political, social, economic, and cultural priorities. It constitutes 3 interrelated and cumulative rights of Indigenous peoples. And then it goes on, and it has a very clear definition, and it's consistent with the definition that was outlined by the Federal Justice Department. And I'm sharing this because even in the child care legislation, the Liberal government, the Liberals pushed really hard not to include free, prior, and informed consent on matters impacting our children. And there seems to be a pattern of behavior when it comes to the United Nations Declaration on the Rights of Indigenous People, the very core of it, which is free, prior, and informed consent and self-determination, that the Liberals continually disrespect. Now, I did manage to work with the Conservatives on the child care legislation, and we did get FPIC passed in the child care legislation, but using the excuse that we don't know what FPIC is, it's not accurate and not honest, and we have a definition in the Federal Justice Department. Thank you. And it goes on. We can read it. But.
Thank you very much, Ms. Guzan. Next, we're going to go to Mr. Batiste.
Once again, I'll ask the NDP. I understand all that about FPIC. I'm in favor of it. I'm in favor of UNDRIP. My father was one of the original drafters of the United Nations Declaration of the Rights of Indigenous People. I'm asking you, how does a First Nations community demonstrate that in reality? I need the answer as to what are you making a community do? There's 630 out there. I live on a reserve. Please tell me the instrument you're telling the community to do that. What's the instrument that a community uses to demonstrate that? Just in plain talk. What does your band have to do?
Thank you very much, Mr.
Am I
Batiste.
supposed to answer?
I'm not going to put you on the spot. If you'd like to, I'm happy to pass the floor to you.
I do know.
Well, then,
Okay.
Then if, Ms. Guzan,
So-
if you'd like, I'll pass the floor to you.
So, I appreciate the insistence to fight. I mean, it's bizarre. Sorry. Through the chair, please. Can you please speak through the chair?
So,
Thank you.
No answer.
I understand his insistence, certainly towards me. It is bizarre that a First Nations person is trying to water down his rights. But in saying that, the Justice Department has been very clear, and I'll read the definition into the record again. We have a definition. I can read the whole definition from the Federal Justice Department. References to free, prior, and informed consent are found throughout the Declaration. They emphasize the importance of recognizing and upholding the rights of Indigenous peoples and ensuring that there is effective and meaningful participation of Indigenous peoples in decisions that affect them and their communities. There are 3 things that you must have for free, prior, and informed consent. 1, free from manipulation. This is certainly not what has occurred in the water legislation. When we meet a chief today who hasn't even heard about the legislation, who's getting secondhand information about what its intent is, where it's at in terms of meeting UNDRIP standards, that is manipulation. 2, or coercion. We need to pass this bill really fast, or it's not going to happen. We need to push this bill through, even if it doesn't meet UNDRIP standards. Threatening. That would be coercion. That would be threats. Informed by adequate, timely information, okay, informed, knowing what you're actually agreeing to. The chief we met today didn't even know about the bill. And prior. So that has not happened with the bill. That's why it's so important that we have free, prior, and informed consent in this bill, because this kind of behavior First Nations people need to have protection from. Even with this water bill, where First Nations are being placed in a position to accept a bill that doesn't meet UNDRIP standards, or we have to worry about clean drinking water. That very behavior in itself is why we need free, prior, and informed consent. How do you do that? By doing all of those things. That's very clear to me. That's the international definition. I'm not making these things up. It's also consistent with the UN expert mechanism. So we have a path forward. The question is this government going to throw free and prior and informed consent of Indigenous people in the toilet, or are they serious about reconciliation? That's my answer through you, Chair. Thank you.
Thank you very much, Ms. Guzan. So not seeing any further.
Through the Chair.
Members, please remember to direct your interventions through the Chair. But not seeing any further debate here, I think we can go to a vote. So first we need to vote on the sub-amendment. So shall the sub-amendment carry? Looks like okay. On division, shall CPC 7 as sub-amended carry? Okay, looks like on division. Okay, so CPC 7 as sub-amended is carried, which takes us to clause 22. So shall clause 22 as amended carry? On division. Okay. Which then takes us to clause 23 and NDP 44. So at this point, I'll open the floor back up to the NDP for NDP 44. So, Ms. Idlaut, the floor is yours for NDP 44.
Which number?
We're on to clause 23, and the first amendment that we have under clause 23 is NDP 44.
Okay. Koyanami Ixivatari NDP 44 is an amendment that was submitted to us by the File Hills Capel Tribal Council. In their request to have Article 23 amended, the wording that they've suggested to improve this bill is by replacing line 29 on page 13 with the following. Sub 2, the agreement must include B, by adding after line 3 on page 14 the following. C, plans and policies that address water, source water, clean and safe drinking water, wastewater, and related infrastructure on First Nations lands. Koyanami.
Thank you very much, Ms. Idlaut. NDP 44 has been moved, so I'll open the floor up for debate. Should any member wish to make an intervention? Okay. Not seeing any debate. Mr. Baptiste?
We're trying to find it in the notes here. We can't seem to find it, so you want to give us a quick second for...
I've got 43 and 45. I can't find 44.
Page?
78 and what then? This?
So we're just going to pause briefly here. just resume this meeting. And we were, Mr. Batiste had the floor, but there was some confusion here, and we were starting the debate of NDP 44. And just want to open the floor up if anyone would like to intervene. Ms. Atwood.
So certainly okay with the C part of it, just addressing additional possible things that could be found in an agreement. But the key to this piece is the may, because it's giving them the power to create whatever they want in that agreement. So the must is telling them exactly what they have to do. So I can't take the must part, but the other C is good with me. I notice my cheeks are very red. We're doing lots of hard work here, folks.
Thank you very much, Ms. Atwood. I'm going to turn it over to Ms. Idlout.
I would be willing to consider a sub-amendment to replace the word must to may.
Must, keep the C, but keep the may. Good?
I'm okay with that.
Easy peasy?
So it looks like there's general agreement on that. I'm just quickly seeing if there's a way we can do that without having to go through translation and all this. So we'll wait one minute here. Okay, we're back. Just want to make sure that there is agreement amongst around the committee here for the sub-amendment, which would essentially delete the amendment part A, which would thereby change it to what it was originally, which is the agreement may include, instead of what was proposed in this amendment, which says the agreement must include. Is there agreement around the table?
But and it also keeps the C though, right?
It keeps the C, but it just gets rid of the paragraph A. Okay, great. Okay, well, it looks like we have unanimous consent there. And so the motion is thereby sub-amended. And we'll open up, is there any debate on the motion as sub-amended? If not, okay, shall NDP 44 as sub-amended carry? Okay, looks like on division. Okay, which takes us to NDP 45. And I'll open up the floor to Ms. Idlout.
Kuyanami Exhibitory NDP 45 was submitted to us by the Federation of Sovereign Indian Nations. They suggested that Article 23 can be improved by adding sub 3, which I will read right now. For greater certainty, nothing in subsection 1 is to be construed as preventing a First Nation governing body from entering into an agreement with the Treasury Board to support the exercise of the jurisdiction referred to in Section 6 or the purposes of Sections 24 and 25. Kuyanami.
Thank you very much, Ms. Idlout. So NDP 45 has been moved. Is there any debate? Ms. Atwood.
Just a question about, I think it's the first time where we see Treasury Board in the bill. Are there any kind of implications to that? as far as, again, the scope of the bill and its intention, but just curious. Yeah.
Thanks for the question. It is the first reference, the Treasury Board. I guess the bill names the Minister of Indigenous Services Canada, so this introduces a new party into some arrangements. So it's not entirely clear in my mind what Treasury Board would do in this case. If this is maybe intended to be a financial arrangement, that's typically with the Minister of ISK or Finance Canada. Treasury Board usually supports the implementation of programming or the administration of funds. So it certainly is a new party. And the Minister of ISK is named kind of throughout, as you've commented many times. It's not entirely clear in my mind, at least, what the Treasury Board relationship or agreement making would be in this case.
Not seeing any other hands up. Let's go to a vote. So shall NDP 45 carry? Okay, I think we need a recorded division.
Ms. Atwin?
Oh, no.
No. Mr. Baptiste?
No.
Mr. Carr?
No.
Mr. Fonseca?
No.
Mr. McLeod?
No? No.
Mr. McLeod?
No. No.
Ms. Equip-Newman?
No.
Mr. Vidal?
No.
Mr. Shields?
No.
Mr. Zimmer?
No.
Mr. Lemire?
Contre.
Mrs. Lout?
Yes.
Yeas 1, nays 10.
Okay, NDP 45 is defeated, which takes us to Clause 23 as amended. Shall Clause 23 as amended carry? Okay, looks like we've got, I'll just say on division for that. And shall Clause 24 carry? On division. Okay, carried. Which takes us to new Clause 24.1 and CPC 8. And I'll just mention that I will have something to say about this particular amendment should it be moved. And with that, I'll open the floor up to Mr. Vidal.
Thank you, Chair. On behalf of Mr. Malello, I will move CPC 8, that Bill C-61 be amended by adding after line 8 on page 14 the following new clause, 24.11. A First Nation law does not apply in a protection zone unless the minister enters into an agreement with the First Nation governing body that made the law and the government of the province or territory in which the First Nation lands are located, respecting the administration and enforcement of the First Nation law. And 2, the parties to the agreement may include a municipal government or any public body acting under the authority of the First Nation. And if you have something to say about it, Chair, I think I will just maybe wait till you have your say before I proceed any further, if that's all right.
That's quite all right, Mr. Vidal. So, unfortunately, I need to make a ruling on this. The amendment proposes to place the responsibility for entering into agreement on the minister. As the House of Commons Procedure and Practice 3rd edition states on page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. And in the opinion of the chair, this goes against the principle of the bill. Therefore, the amendment is inadmissible. So, I know, Mr. Vidal, you mentioned you might have something to say, but if not, then that ruling will stay as is, and we'll move on to the next clause. Mr. Vidal, the floor is yours.
Thank you, Chair. Sorry, I don't have a lot of history here, and I'm following the lead a little bit of my colleague, but I would actually like to challenge your ruling on this. And if the committee would indulge me, I'll just explain a little bit why our side maybe disagrees with this. Protection zones apply in areas which will typically be areas of land not owned or regulated by federal government. Water is also a resource, with some exceptions like navigable waters that is regulated by the provincial governments. This amendment is consistent with the requirement in paragraph 6.1b that a First Nation, federal government, and the provincial territorial government need to agree on an approach to coordinate the application of each government's laws in these protection zones. The onus of reaching the agreement would be on the federal minister, not on the First Nation or the provincial government. This addresses concerns raised by the nations about having to take the lead in negotiating these agreements. It would also just stipulate what the agreement would likely already include. Sorry, it would also just stipulate what the agreement would likely already include, but require it to be part of it. While protection zones remain undefined in the bill, we need to carefully consider its impacts. I understand that we're still working on that definition, so this may become a factor later. These zones, depending where and how big they are, could affect a large number of individuals who reside or work in the area. There needs to be a clear consideration as to how First Nation laws will be implemented, shared with those who reside and work in these zones, and how they will be enforced.
Point of order.
So I don't think I'm going to.
No, there's a point of order.
Just procedural, I think once you have called into question the ruling of the chair, we have to go right to a vote.
It's true. I was giving some leeway to Mr. Vidal here, but technically that is true.
Can I go right to my conclusion?
Just go to the conclusion, and then we'll
I'll
go to a
skip
vote.
the rest, okay? I will end with that we'd just like to emphasize that there needs to be clear consideration for how laws in a protection zone will be applied and enforced to ensure that residents and workers in the area can be made aware of the new laws that they would need to follow. A collaborative approach will ensure that we can achieve this with the bill and its intended goals.
Thank you, Mr. Vidal. So with that, we will go to the vote. Mr. Clerk?
Sustain.
Mr. Baptiste,
Sustain.
Mr. Carr,
Sustain.
Mr. Fonseca,
Sustained.
Mr. McLeod, Mr. McLeod,
Sorry, sustain.
Miss Krempniman,
Yes, support.
Mr. Vidal,
Support the challenge.
yeah, but I understand the challenge. Yeah, so, nay. Mr. Shields,
Support the challenge.
Mr. Zimmer,
Support the challenge as well.
Monsieur Lemire,
Je ne suis pas sûr comment le formuler, mais en faveur de soutenir la décision.
Well, I will support the decision of the chair.
Yeah, yeah. I support the decision of the chair.
Yeas 7, nays 4.
Okay, so the decision is sustained, which takes us to clause 25. And NDP 47 is the next amendment. So I will open the floor up to Ms. Idler.
Koyanami Exhibitary NDP 46 was an amendment submitted to us by the Okanagan Indian Band.
Sorry, Ms. Idler, I hate to interrupt, but we're on NDP 47.
Oh, sorry, did I delete 46?
That's in the last meeting that was withdrawn pursuant to the request, I believe, from AFN.
I am, Sebastian is my good friend. NDP 47 was submitted to us by the Federation of Sovereign FSIN. Sorry, I forget the name of the group. I feel so bad. Damn it. Yes. Sovereign Indigenous Nations. and it seeks to improve the bill by amending Article 25 by adding Sub C, the administration and enforcement of First Nation regulations and those.
Very much, Ms. Idlout. NDP 47 is moved. We'll open the floor up to debate. Does any member like to make an intervention? Ms. Atwin.
I think I'd like to put forward a sub-amendment, and so I'll need you to suspend if possible, so I can do that. Could we suspend briefly, just so I can put forward a sub-amendment?
Yes, absolutely. We can do a brief suspension here. So we left off, there was discussions about a sub-amendment, which has now been circulated. I'm just going to read off the sub-amendment. and that's to sub-amend NDP 47. And how this will read is, in the bill at page 14, lines 18 and 19 in English would read as follows. Subsection C, the administration and enforcement of First Nations laws and the administration and enforcement of regulations made under subsection 19.1. Et en français, à la page 14, les lignes 21 et 22.
Line 21-22 would read as follows. The administration and implementation of the laws of First Nation, as well as the administration and implementation of regulations taken on paragraph 19 rather.
So with that, Ms. Atwin, you had the floor to move it, so I'll pass it back to you.
I move the amendment as read out by the chair. I can certainly do that again. Really, it's just combining the amendment that Ms. Idlet put forward, and then, but also in the spirit of the original section C of that part of the bill, and so it's kind of marrying them together. So I think I don't know if I need to explain further, but so it's basically just again containing federal role and agreements and federal responsibilities, and is anticipated to be aligned with First Nation priorities, and I think that's so moved.
Great. So that amendment has been moved. Is there any debate around the table? Not seeing any debate. Let's move this to a vote. So shall the sub-amendment to NDP 47 carry? Okay, carried on division, which takes us back to NDP 47 as sub-amended. Is there any debate? Not seeing any. Shall NDP 47 as sub-amended carry? Okay, looks like on division. So NDP 47 as sub-amended carries. So at this moment, we're moving to, so shall clause 25 as amended carry on division, which takes us to new clause 25.1, et BQ 19. Et je vais donner la parole à Monsieur Lemire.
And the floor goes to Mr. Lemire. NDP 49 was withdrawn? Yes, it was. Okay, thank you very much, Chair. The information that we're hoping to acquire here is a transparency. So, and it should be clear, even on the website of the government. It would allow certain measures to allow First Nations to develop their position with FIPIC.
Si quelqu'un veut...
Thank you, Mr. Lemire. I'll open the floor up for discussion and debate. Ms. Allen.
VQ 19, right? And so I see that it's a new clause. It's quite substantial. And so there's actually already in Section 9 of the bill, a First Nation governing body that makes a First Nation law must, as soon as feasible after it makes the law, publish it on its or the First Nations website, if any, and in the First Nations Gazette. So there is a process in the bill that was already developed specifically by First Nation partners and with their language. And so because of that, I would be opposed to this amendment.
Thank you very much, Ms. Atwin. Is there any other debate? Okay. Not seeing any other hands up. We can move this to a vote. Shall BQ 19 carry? Looks like we don't have agreement, so I guess it won't carry on division. Okay, then we'll go to a deferred recorded division here. Mr. Clerk.
Ms. Atwin?
No.
Mr. Baptiste?
No.
Mr. Carl? No. Mr. Fonseca?
No.
Mr. McLeod?
No.
Ms. Quempneman,
Yes.
Mr. Vidal,
Yes.
Mr. Shields,
Yes.
Mr. Zimmer,
Yes.
Monsieur Lemire,
En faveur.
Mrs. Laut,
Akapunga, no.
Yeas 5, nays 6.
Okay, so BQ 19 is defeated, which takes us to clause 26. And the first amendment we have here is NDP 50. Also just mention I will have something to say if NDP 50 is moved. And with that, I'll open the floor up to Ms. Idlout.
Koyanami Ixivautari NDP 50 was a submission that had several First Nations speaking to it. It seeks to improve Bill C-61 by amending Article 26, where the Bill C-61 in Clause 26 was be amended by replacing lines 30 to 32 on page 14 with the following. The minister must ensure through funding that access to clean and safe drinking water. Kuyanami.
Thank you very much, Ms. Idlout. Unfortunately, I need to make a ruling on NDP 50. The amendment attempts to create an obligation for financing that does not currently exist in the bill. As House of Commons Procedure and Practice 3rd edition states on page 772, since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury, or if it extends the objects or purposes or relaxes the conditions and qualifications specified in the royal recommendation. And in the opinion of the chair, the amendment proposes a new scheme which imposes a charge on the public treasury. Therefore, I rule the amendment inadmissible. Okay. So that said, that moves us to PV3, which is deemed moved. And I would also like to welcome Mr. Morris back to the committee. And I'll pass the floor over to you. And just before doing that, I'll mention that if PV3 is adopted, PV4, NDP 53, NDP 54, NDP 51, NDP 52, and PV5 cannot be moved due to a line conflict. So with that, Mr. Morris, the floor is yours.
The numbers.
Gladly. So it's PV4, NDP 51, 52, 53, 54, and PV5. Okay, with that, Mr. Morris, over to you.
Thank you, Chair. As I've shared in my past interventions on C61, these are two more amendments, PV3 and PV4, that come directly from Six Nations of the Grand River. They're specifically to the section of the bill that we heard significantly from Chief Hill, and I understand many others in their testimony to this committee with respect to the insufficient current language of best efforts. The current bill reads, the minister in consultation and cooperation with a First Nation governing body must make best efforts to ensure access to clean and safe drinking water, whether from a public or private water system is provided to all residents, occupants, and users of buildings located on the First Nation lands of the First Nation. Both PV3 and PV4 seek to remove the wording best efforts, simply replacing with the requirement that the minister must ensure. PV3 includes more specificity about what a building is, including homes. I'll note that MP Idlout has very similar amendments, all of which also get rid of that language. And so it looks like members of the committee have multiple options for preferred text to follow what they heard from Six Nations of the Grand River and many others to improve the language of this bill to meet what we heard quite a bit, which is that a best effort to provide safe drinking water isn't good enough, and we must follow through on that. And this is a bill that gives us an opportunity, gives the Government of Canada the opportunity to do that. PV4, which follows, is a briefer version of the same, which simply removes the words make best efforts. And as I said earlier, MP Idlout has also provided several other options that I'm sure she'll be speaking to. Thank you.
Thank you very much, Mr. Morris. So with PV3 moved, we'll open it up to debate. I see Ms. Atwin has her hand up. I'll go to you first.
Thank you, Mr. Chair. And thank you, Mr. Morris, for joining us. And we heard significantly from many of our witnesses about the term best efforts. And I too, kind of questioned that language and, where it's coming from and what the intentions are. And I also completely understand the distrust that exists, of course, within First Nation communities and membership and relationships with the government as a colonial entity. However, I've come to learn, and through the legal precedent, that best efforts is actually the strongest language that we have to ensure that those that what we want to achieve in Bill C-61 will be met. And so I think it's actually stronger to keep the best efforts, and I worry that removing that is actually weakening because it's not covering all of the bases to ensure that that's met. Also, I mean, we do also have the piece around human rights that's in the bill, as I mentioned before, so it's an additional layer. But I'm also, concerned that it's also going to force the Government of Canada to intervene on First Nation lands in situations that would be best left to specific First Nation communities as well. So surveilling those specific buildings you're mentioning, I'm just not sure about the mechanics of that and what that would look like. So again, I go back to the idea that best efforts is the strongest possible language that we actually have in legal terms today. And I hope I'm getting that correct. Maybe I could refer to our legal expert here and officials.
So best efforts is a fairly high standard. Oh, thank you. Yes, best efforts is a very high standard. It's certainly higher than reasonable efforts, which was the term used in the Safe Drinking Water Settlement Agreement, for example, from 2021. Without best efforts, though, indicating ensure is slightly higher than best efforts. So must ensure would be a greater obligation. Yeah.
Thank you very much, Ms. Atwin. Not seeing any further interventions. Ms. Idlout.
I'm just wondering, just technically, with PV4, NDP 51, 52, 53, 54, 55, like what those similarities and differences will be if we pass PV4, just because I can't do the analysis quickly enough by myself to try and determine whether I want to support PV4. I wonder if we could get advice from the experts about those provisions, because depending on the responses, I will also submit a sub-amendment, which I had already submitted before, if we do pass, if we do tend to pass PV3. Yeah.
Sorry, if the question is compare and contrast, I would probably turn it back to the chair.
Yeah, so I think the question that was asked was, how PV3 compares to the other related amendments that all deal with the same paragraph. So that would be, so PV4, NDP 53, NDP 54, NDP 51, 52, and PV5. Very simple question.
Yeah, thanks. Okay, I appreciate the question. Maybe I'll start at the beginning, focusing at PV3 at hand here. How this reads to me in isolation is this would compel a First Nation. A First Nation must provide for clean water for all residences in their home. This is binding on a First Nation, not on Canada. It would have an ancillary effect on Canada, but this would compel First Nations action. I also feel that just to take us back to, I think, day one or day two, we enshrined in the proposed legislation in this legislation already, in proposed legislation, is a domestic right for First Nations to have access to clean drinking water. I would be concerned about the competing factor there. The precedent in law would be historic if the past G1 in this legislation becomes enshrined in law, and so I feel that is a very significant bar. And I haven't done the legal analysis, and I'm not a lawyer, to compare and contrast those things, but the bar is very high because of G1, and it's enshrining for the first time ever a domestic right for all First Nations to have clean and safe drinking water. And I could stand corrected, so apologies to the chair, but this seems like it's binding on a First Nations government body to provide those actions.
Thank you very much, Ms. Atwin. Next, I see Mr. Morris has his hand up, so we'll go to Mr. Morris.
Thank you, Chair. I just need to correct Mr. Barboza. I'll read the beginning of clause 26. I think Mr. Barboza might be recognizing that it starts on line 2 of the clause. So I'll read it out again so that we're all clear. This does not put any additional responsibility on the First Nation. Rather, this is about the duties of the minister. Line 1 says, the minister, in consultation and cooperation with the amendment would change it to First Nation governing body. So the minister, in consultation and cooperation with the First Nation governing body, must, and goes on to ensure that all residents, legal occupants, and users of buildings. We also just heard from Mr. Fairbairn that the legal precedent is that must ensure would put a higher level of responsibility on the Government of Canada than make best efforts. And I believe, to MP Idlaut's question, every one of the next few amendments switches to that must ensure in place of make best efforts, and that there's various additional words in PV4. Speaking to the amendment I brought forward, there's additional clarity on what a building is versus in the case, sorry, that's PV3. PV4 is simpler to remove make best efforts to the minister must ensure. Hope that provides clarity for you, Chair, and to members of the committee.
Thank you very much. Mr. Morris. Okay, not seeing any further debates here. Ms. Atwin.
Just for you, Mike, where you've added legal occupants versus occupants, can you just explain that?
Yes, so in PV3, Six Nations of the Grand River was looking to ensure that the Government of Canada understood for homes to be included, and so I can read out PV3. Rather than simply saying from the public or private water system, PV3 goes on to explain for all residents, legal occupants, and users of buildings, and then has an additional greater certainty that the buildings referred to that earlier section include homes. And then goes on to share uses of water in homes.
I certainly get that, but I just mean you've added legal before occupants, which it wasn't previously there. Can you what does that refer to? How do you define a legal occupant for a First Nation home?
Yeah, great question. I would welcome a friendly amendment if other members of the committee felt that legal occupant was unnecessary or can turn to witnesses. Legal could be removed if that was seen as problematic for members of the committee.
Okay, next I have Ms. Idlaut.
So I'm looking at PV3 and DP 51. just as an example, PV3 is talking about must ensure that all residents, legal occupants, and users of buildings located on the First Nation lands of the First Nation have regular access to clean and safe drinking water in those buildings. So the first part is focusing on buildings. For greater certainty, the buildings referred to in subsection 1 include homes and having regular access to clean and safe drinking water in relation to a resident's or legal occupant's home refers to having in such a home drinking water of quality and quantity sufficient for all usual and necessary uses of water, as in similarly situated non-Indigenous home. So this one is focusing on homes, whereas for me, what I see NDP 51 reading differently is First Nations governing body, must ensure that access to clean and safe drinking water of a quality that meets the standards set out in Section 14, whether from a public or private water system, is provided to all residents, occupants, and users of buildings located on the First Nation lands of the First Nation. B, access to water of quantity that meets the standards set out in Section 15 is available on the First Nations lands of the First Nation. And C, wastewater effluent treatment meets the standards set out in Section 16 so that all residents, occupants, and users of buildings located on the First Nations lands of the First Nation can benefit from it. So for me, NDP 51 seems to be quite different from PV3 because NDP 51 talks about standards and standards that need to be met, and I don't understand how it could be ruled that if we vote in favor of PV 53 that we wouldn't be able to vote for NDP 51.
So let me just quickly check into those ones, because there's the PV3 one, and then there's, my understanding is there's a line conflict in the actual legislation, so it would amend something which would change that one. But just so I'm, make sure I have that correctly, are you asking why if we vote in favor of PV3, why NDP 53 and 54 would be, would not be able to be moved?
All of them, you said PV4, 51, 52, 53, 54, and PV5.
Yes, so these all, they make amendments related to the same paragraph, and there's a line conflict that's there, and so those ones wouldn't be able to be moved. Okay, so thank you very much, Ms. Idlout. Mr. Morris?
PV3. Thank you, Chair. I think based on that input from MP Idlout, I would agree with her that NDP 51 would offer stronger language. And so for that reason, I'm happy to withdraw PV3 and move us to discussion on PV4.
So thank you, Mr. Morris. In order for that to be done, given that it has been moved, we'll need unanimous consent for members in the committee. And I just want to make sure that amongst the committee here, we have unanimous consent for Mr. Morris to withdraw PV3. Okay, not seeing any disagreement. Okay, so PV3 is withdrawn, which takes us to PV4, which is automatically deemed moved. And since PV4 was deemed moved, NDP 53, 54, 51, and 52 cannot be moved because they're identical. Mr. Morris.
Yeah, thank you, Chair. And so PV3 gets at the same input from Six Nations of the Grand River, and that is specifically to remove best efforts. We've heard from witnesses from the department that removing best efforts increases the responsibility on the Government of Canada to must ensure. I think the interest of Six Nations of the Grand River was for any of these options that increases that responsibility. Should it be PV3 or NDP, any of the NDP amendments that follow? I think the larger interest was to increase that level of responsibility, as we also heard from other First Nation witnesses to this committee. This being a real opportunity in this legislation for the government to ensure that safe and clean drinking water is provided. Thank you, Chair.
Thank you very much, Mr. Morris. I'll open it up to debate, and Ms. Idlout.
Could you remind me again, if we pass PB4, which amendments wouldn't be able to be debated?
So it would be NDP, well, thank you, Ms. Idlout. It would be NDP 53, 54, 51, and 52.
And there's also a line conflict with NDP 51 and NDP.
Just to clarify here, 53 and 54 are identical to PV4, but if there is a line conflict with 51 and 52, so if this was to pass, then those ones wouldn't be able to be moved. Ms. Idlout.
Could we understand, can it be explained to us what the line conflicts are and what the difference between 51 and PB4? What the practical effect would be?
Okay, so I think that's that's two questions. Number one, how they're the line conflict, and then so first we'll address that, and then we'll turn it over to our witnesses to be able to speak to the difference, pardon me, in the legal effect that they would have. Okay, so the conflict is line 31 on page 14. So that's the conflict. So they all address that same line. And I will turn it over to our witnesses here to speak to the differences of those different amendments that were put forward.
Appreciate the question. So the significant difference is really in NDP 51 has a lot more details in terms of kind of qualifying the provision of safe drinking water on what terms. So it's a lot more constrained than open-ended in the other amendment PV4. Would also just note that kind of all these efforts would be implemented through funding, which could create some considerations for Parliament when allocating funds, just so folks are aware, as well as the consideration around self-determination. As the spirit of this bill is really to support First Nations in advancing their visions of self-determination, this would place a more active role of the minister versus a less active role of the minister in a First Nation determined vision. Thank you.
Thank you very much, Ms. Idlout. I see Mr. Morris has his hand up, so we'll go there next.
Yeah, I just want to clarify again the wording here. This is not about roles. And so we're heard from Ms. Blake just now about the role. This is in a section called Powers, Duties, and Functions. And specifically, the text is about the minister must accomplishing a thing. In this case, must ensure that. And so I just think it's important to clarify that that's not the text that we have in front of us here, that this text, in any of the amendments that follow, whether it's PV4 or the NDP ones that follow, are clarifying a responsibility of the minister rather than taking any self-determination away from a First Nation. I guess I would turn to the witness to clarify if that's the claim, where that is in the bill.
Appreciate the precision on language and agree we're in the section on powers and duties. So I was just using a synonym for the name role, but agree with you, absolutely.
Thank you very much, Mr. Morris. Ms. Idla, I'll turn the floor back to you.
Just a very quick clarification. If we pass PV4, then we can't debate NDP 51?
No. That's correct.
Okay, so just seeking clarification on the differences between PV4 and NDP 51, because I do see that there's a difference. I don't know what the line conflict is, and I wonder if we could get that explanation, because to me, PV4 is clearly setting a higher standard of what the minister must do. And in addition, NDP 51 talks about standards that are in these specific areas outlined in A, B, and C. And I wonder if they can clarify how the comparison between the two.
Appreciate the question. The standards section in the bill, as debated through this committee, provides for the choice in terms of First Nations and application of standards. So it could potentially be with NDP 51. You know, it does say as set out in those particular sections, but it might add additional prescription that's not already covered in the standards section.
Thank you very much, Ms. Idlaut. Et au prochain, on va aller à Monsieur Lemire. La parole est à vous.
Simplement mentionner qu'on va supporter PV4. Merci.
Merci beaucoup.
Thank you very much.
Monsieur Lemire had he said that he's going to be supporting this amendment. So not seeing any further interventions, I think we can go to a vote. So shall PV4 carry? Okay, I think we need a deferred recorded vision.
Ms. Atwin?
No.
Mr. Baptiste?
No.
Mr. Carr?
No.
Mr. Henley?
No.
Mr. McLeod?
No.
Ms. Webb-Newman?
No.
Mr. Vido?
No.
Mr. Shields?
No.
Mr. Zimmer?
No.
Monsieur Lemire?
En faveur.
Ms. Idlaut?
Yes, Angik Punga.
Yes, 2, nays 9.
So PV4 is defeated, which takes us to NDP 51. And I'll open the floor up.
No, sorry. No. I think it's already, oh, sorry. Sorry about that.
Sorry to interrupt here. Just going to suspend very briefly to double check something. And I'm very sorry to have interrupted there. Colleagues, we're back. Apologies for the short break there, and apologies for interrupting there, Ms. Sidlout. I'm going to turn the floor back to you.
Okay, thank you. I think in my line of questioning, it's already clear what NDP 51 attempts to do, so I'm not going to summarize, and I'll just move NDP 51.
Thank you, Ms. Idlout. NDP 51 is moved, and I'll mention that if NDP 51 is adopted, both NDP 52 and PV5 cannot be moved due to a line conflict. So with that, I'll open it to debate. And not seeing any hands up. I know we've debated related motions here. Just give a short moment here. But if there aren't any more interventions, then we can move to a vote. Okay, so shall NDP 51 carry? We'll go to a vote.
Mr. Twain.
No.
Mr. Baptiste.
No.
Mr. Carr.
No.
Mr. Henley.
No.
Mr. McLeod. Mr. McLeod.
You just call him again.
Mr. McLeod.
Mr. McLeod.
No.
Just mention him one more time.
You got to tell him what to vote.
Excuse me. Okay, we are voting on NDP 51. No. Okay. Miss Cramp Newman.
No.
Mr. Vidal.
No.
Mr. Shields.
No.
Mr. Zimmer.
No.
Monsieur Lemire.
En faveur.
For.
Yes.
Yes, 2, nays 9.
NDP 51 is defeated, which takes us to NDP 52. And I'll open the floor up to Ms. Sidlow.
Koyanami Exhibitory NDP 52 seeks to amend Article 26 by replacing lines 31 and 32 on page 14 with the following. First Nations governing body must ensure that access to clean and safe drinking water that meets the standards set out in sections 14 and 15 by replacing the line 2 on page 15 with the following. Ings located on the First Nation lands of the First Nation and that wastewater effluent treatment meets the standards set out in section 16 so that all such residents, occupants, and users can benefit from it.
Thank you very much, Ms. Idlout. So just want to notify members if NDP 52 is adopted, PV5 cannot be moved due to a line conflict. So with that, I'll open the floor to debate. And I know, of course, we've debated related issues, so not seeing any hands up. Let's move to a vote. So shall NDP 52 carry?
Mr. Twain.
No.
Mr. Baptiste. No. Mr. Carr.
No.
Mr. Henley.
No.
Mr. McLeod.
No.
Ms. Cramp Newman.
No.
Mr. Vidal.
No.
Mr. Shields.
No.
Mr. Zimmer.
No.
Monsieur Lemire.
Contre.
Mrs. Lau.
Yes.
Yes, 1, nays 10.
So NDP 52 is defeated, which takes us to PV 5, which is deemed move. And I'll open the floor to Mr. Morris to be able to speak to this.
Thank you. Speaking to this on behalf of our colleague, Ms. May, failing to have improved the responsibility earlier in this section, this amendment seeks to increase the obligations in a different manner later on in the section by adding words at the end of the sentence. So currently it still says must make best efforts to ensure that access to clean and safe drinking water, whether from a public or private water system, is provided to all residents, occupants, and users of buildings located on the First Nation lands. In a manner that is the addition in this amendment, as a minimum, meets the obligations set out in sections 31, 33, and 34 to follow of this bill.
Thank you very much, Mr. Morris. With that, we'll open it up to debate. And first, I see Ms. Atwin has her hand up.
Thank you, Mr. Chair. And I thank Ms. May for bringing this forward as well, one of my also very esteemed colleagues. I think very supportive of this, especially because it really speaks to a written brief that we received from the First Nation Advisory Committee. But I would like to put forward an amendment, a sub-amendment, sorry. It's been sent, I believe, to our clerk and hopefully distributed. So it's basically the amendment, so it's supporting as follows. So it's located on First Nation lands of the First Nation in a manner that meets the obligations set out in sections 31, 33, and 34. So it's again supportive of adding that additional clarifying language that connects to those funding obligations in the co-developed funding framework.
Thank you very much, Ms. Atwin. We're just going to suspend very briefly to make sure we can have that circulated to everybody, and then we can continue the debate at that point here. we've got, so the amendment was circulated to all members' emails here. While it was a very simple thing to change in English, it was a little bit more complicated with the translation, so you should have that now. And I'll turn the floor back to Ms. Atwin if there's anything more she'd like to say on this.
So just to clarify, it's just taking out as a minimum. So it's just pretty simple.
Open up to debate. Ms. Idlo.
I just need to ask a question about Article 26 because it's talking about best efforts, and I still don't really understand the analysis behind it. When I did a quick search in Candly, all of the case law related to best efforts only speaks to contract law cases, and I wonder how best efforts is being interpreted in this legislation to be so high.
So yes, best efforts is a very high standard. You're right, a lot of best efforts references are in contract law, but it's not exclusive to contract law. So basically, in this situation, the minister would have to take every possible step she could to ensure safe drinking water on First Nation lands. So she would have to work with her colleagues in cabinet, she would work with officials to ensure that this safe drinking water was delivered. So it's, in terms of, standards, there's, in law, there's a reasonable efforts. That was used in the settlement agreement. It's a lower standard. Still, you have to take significant steps to achieve a goal. Best efforts, you have to make your maximum effort to achieve a goal. You don't necessarily, if you do not achieve that goal, you would not necessarily be penalized for that. But if you did not make every attempt to achieve the goal in the context of this legislation, then the minister would be failing in her obligations. So it is some slightly lower than must ensure, but it is a very high standard for the minister to have to achieve.
Describe what that slightly lower means. Like, if I think it's been pretty clear by now that I've been here fighting for First Nations rights. First Nations have repeatedly asked us to make sure that C61 is better for them, and I know that if we weren't able to get best efforts replaced with must, that it will be very difficult for us to persuade First Nations that we're doing our job because of a slightly lower standard. So I wonder if you could better explain to us how best efforts is such a high standard when it comes to First Nations water. First Nations water, where we need to reconcile what this government has done to First Nations to end up having them in conditions and situations where they might for another 50 years live in boil water advisories, where First Nations will have to most likely negotiate with provinces and territories over decisions that should have remained in First Nations authority. So I really need a clearer understanding of why best efforts is such a high standard when First Nations are very clearly asking for amendments to best efforts to be changed to have it changed to must, because when the government stole that authority, not only did they do it by putting First Nations into bans, but enforcing them to live under the Indian Act, and then keeping them suppressed by underinvesting in them for decades, for hundreds of years. So how can we possibly persuade First Nations that best efforts is something that is acceptable to anyone?
Appreciate the question. Read in the context with other kind of provisions and as well as what's already been debated by this committee. For example, my colleague here mentioned the recognition of a human right to safe drinking water on First Nation lands. So that would be in conjunction to this provision as well, and a stronger piece recognizing that human right. In terms of best efforts, practically, it means every single possible effort without having significant impacts on Parliament's ability to allocate funding in cases of emergencies, for instance. So it's every single effort with that one piece in terms of the funding of Parliament being the role of Parliament for all parties to debate.
And how is that different from replacing it with the word must?
My sense of it would be replacing it with the word must might impact Parliament's ability to allocate funding.
Ms. Idlout, I see Ms. Atwin has her hand up. We'll go there next.
And I'm kind of still asking the same thing. And just in my mind, it's like, say there was a war, and that would be an example where extraordinary circumstances perhaps could prevent the government from meeting that funding responsibility because everything's at the war effort. Like, is that how extreme of an example we would have to go to in order to not meet that best efforts threshold without it ending up in court and that responsibility and liability being on the minister and the Crown?
So I think read with other sections in this act, there are sections that we haven't arrived at, but comparable services is a significant piece. We have talked about the funding framework. The legislation proposes to develop a public-facing funding framework on actual costs to maintain and operate First Nations water systems, and so that'll be in the public vernacular. And the minister, regardless of who that person is, must take action and move towards supporting the comparable cost and actual costs of water systems, which would be part of the tabling of this financial report. So it is an extremely high bar, and read with other elements of this legislation, particularly comparable services and funding agreements in the public sphere, would create a significant kind of impetus to support funding through the appropriation cycle of Parliament.
Thank you very much, Ms. Atwin. Not seeing any other debate, why don't we go to a vote on the sub-amendment to PV5? So shall the sub-amendment carry? Okay. I think is there, okay, I guess we can go to vote.
Ms. Atwin.
Yes.
Mr. Baptiste.
Yes.
Mr. Carr.
Yes.
Mr. Henley.
Yes.
Mr. McLeod.
Yes.
Ms. Krepniman.
Yes.
Mr. Vidal.
Yes.
Mr. Shields.
Yes.
Mr. Zimmer.
Yes.
Monsieur Lemire.
Oui.
Ms. Idlout.
Not having heard any real explanation as to how the case law supports best efforts, I'm going to say no to both the sub-amendment and the amendment.
Yes, 10, A1, nays 10.
So
sorry. Yes, 10, nays 1.
So PV5 is sub-amended. Is there any debate on PV5 as sub-amended? Okay, Mr. Morris.
Yeah, thank you, Chair. I'm just wanting to ask a question of witnesses here, because I think the intention of this amendment from Ms. May was to establish a floor, a minimum, that would meet the obligations in section 31, 33, and 34. The committee has now just passed a sub-amendment that removes the floor and simply would have it say that it is in a manner that meets the obligations. I'm not sure that was the original intention of the amendment, and so may I turn it to officials. If it were to pass without as a minimum, what bearing does that have on the responsibilities of the government when it comes to providing funding and following through on their obligations in this act?
Appreciate the question. I'll probably answer it a bit directly. So it refers to provision 34, which already includes the as a minimum, and the floor is already established. So it's to ensure implementation of all those settlement agreement provisions, but also 34 that already establishes that floor.
Okay, so I guess my interest is I'm debating whether to withdraw the amendment now that it no longer has a minimum floor, and I might need unanimous consent to do that. I recognize that. But I'm looking to understand from officials, if it were to pass in its current form as amended, does it increase, make no change, or decrease the responsibility of the Government of Canada?
No change given the existing provisions in the bill.
Okay, so I'll leave it to be voted on. It looks like I might not get UC anyway to take it out, given some of the looks I'm getting, but it looks like it makes no change regardless in its new form. Thank you, officials.
Okay. Is there further debate on PV5 as sub-amended? Not seeing any. Let's move to a vote. So shall PV5 as sub-amended carry?
Satwin?
Yes.
Mr. Baptiste?
Yes.
Mr. Carr?
Yes.
Mr. Henley?
Yes.
Mr. McLeod?
Yes.
Ms. Crump-Newman?
Yes.
Mr. Vidal?
Yes.
Mr. Shields?
Yes.
Mr. Zimmer?
Yes.
Monsieur Lemire?
En faveur.
Mrs. Lout?
No.
Yeas 10, nays 1.
So PV5 as sub-amended carries, which takes us to shall clause 26 as amended carry. Okay, looks like on division. And that does take us to clause 27. We are past the time that we had scheduled for the meeting today. I know we do have a lot of work we need to get done on C61. We do have a long day scheduled for tomorrow. But so I do want to give the opportunity for members if they do want to move a motion to adjourn. But we do have a lot of things that we're going to need to get to. So whatever we don't get to tonight is going to be just more that we don't get to tomorrow.
I move to adjourn.
So Mr. Shields is moving a motion to adjourn, so we'll have, we'll vote on that.
Ms. Satwin? Mr. Baptiste?
No.
Mr. Carr?
No.
Mr. Henley?
No.
Mr. McLeod?
No.
Mr. Crump-Newman?
Yes.
Mr. Vidal?
Yes.
Mr. Shields?
Yes.
Mr. Zimmer?
Yes.
Monsieur Lemire?
En faveur.
Mrs. Lout?
Ang po nga, yes.
Yeas 6, nays 5.
Okay, so we will see everybody tomorrow at 10 a.m.
Aye.